When Richard Jones applied for a six-figure auto loan, he believed he had rights, not just as a customer, but as a party to a legal agreement. When the credit union didn't approve his application, he didn't take no for an answer. He filed a lawsuit. What followed was a lesson in how form, substance, and strategy matter in court, especially when you're on your own. Hi, I'm Yaz from Courtroom 5, and this is Who Wrote That Up for You, the podcast where we follow everyday people fighting their way through civil court without a lawyer. Today's case is Jones v. Alliance Credit Union, out of the Texas Court of Appeals in Amarillo. And it's not just about banking or breach of contract. It's about what happens when you try to fight a legal battle in a language the court doesn't speak. Richard Jones was a man on a mission. In August 2024, he applied for a car loan from Alliance Credit Union, just under $100,000. That's not your everyday Toyota Camry. We don't know what kind of car he wanted, but whatever it was, he thought this application sealed the deal. There's no record that Alliance ever approved the loan. No counteroffer, no denial. Just silence. That might have been the end of the story, but Jones saw more than a missed opportunity. He saw a legal wrong, so he filed a lawsuit. In his complaint, Jones alleged that Alliance had refused to carry out its fiduciary duties, had ignored his tendered negotiable instrument, and had failed to honor something called accord and satisfaction. These terms may sound impressive, even lawyerly, but to a court, they're only useful if they're backed by facts and applied correctly. Alliance responded with a motion to dismiss under Rule 91A of the Texas Rules of Civil Procedure. That rule allows a judge to toss a case that has no basis in law or fact. In plain English, even if every word in your complaint were true, you still wouldn't have a case. The trial judge agreed and dismissed the case. Now, some people would call it quits there, but not Richard Jones. He filed an appeal, still representing himself. In his appellate brief, Jones made 5 key claims: that the dismissal rule was wrongly applied to a case needing fact-finding, that the court ignored evidence, that federal and commercial law were overlooked, that Alliance had a legal obligation to accept his loan application, and that the credit union had violated Section 16 of the Federal Reserve Act. Here's the problem. While the claims were bold, they weren't backed up. The appellate brief didn't cite case law. It didn't include page numbers from the trial record. It didn't explain why those laws applied, or even what evidence had supposedly been ignored. And when the court gave him a second chance to fix the brief, Jones filed a revised version, but it had the same issues. The court reminded Jones that while they do interpret pro se filings generously, they can't do the work for you. They cited cases like Fredonia State Bank and Ross Fears St. Luke's Episcopal Hospital, which say that when a party fails to support their arguments, those arguments are considered waived. So the court never got to the merits. They couldn't decide whether Jones had a valid claim because he hadn't given them anything to work with. The judgment of the trial court was affirmed, and Jones's appeal was over. But the deeper story isn't about who won or lost. It's about what this case teaches us. Richard Jones didn't get to argue his case at trial. He didn't get a hearing. He didn't get discovery. Not because the court was biased or unfair, but because the rules of civil procedure matter. The legal system can't work if it doesn't have structure. But here's the good news. These are skills that can be learned. Legal research, writing a complaint, drafting an appeal, none of it is out of reach. But you need tools, support, and a willingness to speak the court's language. That's where Courtroom 5 can help. If you ever find yourself in a situation like Jones's, where your case gets dismissed before it even starts because the court couldn't follow your argument, go to Courtroom 5. We give you the tools to understand the law, structure your claims, and make your voice heard in a way the court can act on. Don't just speak up. Speak the court's language. Here are some key takeaways from this case. 1. A loan application is not a contract. One of Jones's key misunderstandings was the idea that by applying for a loan and possibly sending a payment instrument, he had created a binding agreement. But in contract law, intent and mutual agreement are everything. A loan application is a request. It's an offer to do business, not a guarantee. Without approval, terms, and acceptance by the bank, there is no contract. That's why courts routinely dismiss breach of contract claims based solely on rejected applications. Jones's references to fiduciary duties were also misplaced. Credit unions don't owe fiduciary duties to people who apply for loans. That term applies in special relationships, like a trustee to a beneficiary or a financial advisor to a client. Just filling out a form doesn't create that kind of legal duty. 2. Speak legal, not legalese. Jones used language like accord and satisfaction and cited the Federal Reserve Act, but without explaining what those meant in the context of his case. Accord and satisfaction is a specific legal concept. It usually applies when one party accepts a lesser payment as full settlement of a debt. It doesn't apply when a loan is simply never approved. When courts read pro se filings, they try to make sense of the intent, but they're not mind readers. They need clear arguments with clear connections to the law. Throwing legal terms into a brief without applying them to your facts is like trying to use a dictionary as a recipe. You'll have all the words, but none of the results. 3. Appeals are not do-overs. This is where a lot of self-represented litigants struggle. The appeals court doesn't rehear the case. It doesn't look at new evidence. Its job is to review what the trial court did and whether the law was followed. That means your appellate brief must follow very specific rules: citations, page numbers, relevant statutes, and structured legal reasoning. Richard Jones didn't do that. Even after being told his brief was defective, he didn't fix the deficiencies. That turned what might have been a teachable case into a procedural dead end. How would you have handled this situation? Drop your thoughts in the comments. And if this episode gave you clarity, or just made you feel a little less alone in your legal fight, share it. Someone you know is struggling to be heard in court, and they need to know they're not alone. This has been Who Wrote That Up For You? Until next time, keep learning, keep pushing, and keep fighting for what's right.
Yeah.